Did you know that you can include your digital footprint in your estate plans? I'm Annie. Join us for this law you can use. Welcome to the Ohio State Bar Association's Law You Can Use, where we answer commonly asked questions about different legal topics. Today we're discussing estate planning and what to consider when it comes to your digital footprint. Joining me is attorney David Lenz. He's a partner at the Cleveland firm of Schneider, Smeltz, Spieth, and Bell. Thank you so much for joining me, David.
Great to be here.
So let's start by defining what digital assets are.
Well, there's been a lot of talk in the popular media about Bitcoin and other cryptocurrencies, and that's what a lot of people think of when they think about digital assets. But really, I think of that as only one of four main categories of digital assets. There are those things that are purely electronic that have an actual monetary value. Then there's online access to your regular financial information, bank accounts, investment accounts. Then there's electronic communications is a third category, particularly your email account, your social media profile, and the private messages in there. And then the fourth category is just sort of a grab bag of any other activities that we used to conduct in paper or physical form that we're now doing online or on our computers.
Mm-hmm. And why should we care about what happens to these digital assets?
Well, the email account, for example, can be crucially important to estate administration. We used to use just the paper mail to understand what the decedent owned after their death. You could get their statements and their 1099s and piece together what the financial picture looked like. But nowadays, most financial institutions are requiring you to have electronic statements or charging you extra money for the privilege of receiving paper statements. But unfortunately, the electronic communications in your email account also have privacy protections through federal law that have made it tricky for executors to be able to get in and access that information. If someone does own Bitcoin or other cryptocurrencies, the private keys to that are the keys to being able to recover that asset, and there may be no central mechanism to recover those, and the assets could just disappear after someone's gone. On the more sentimental side, of course, loved ones are going to want to be able to get access to your photos and videos on your smartphone. A shared electronic device might become unusable if a family member dies and you don't know what the password is. And on the flip side, you may care about your digital assets and making sure that someone doesn't get access to certain information if there's embarrassing or other information that you'd rather not have known by your survivors after you're gone.
So how do we have a say in what happens to our digital footprint or our online presence?
Well, for many years, planning for digital assets and administering them was at a tricky intersection of contract law and federal cybersecurity law and probate law, and there wasn't clear guidance for these particular types of assets. I was pleased to be able to serve on the OSBA's committee that was reviewing legislation in this area and led to the adoption of the revised Uniform Fiduciary Access to Digital Assets Act here in Ohio, which now gives us some guidance on four different types of fiduciaries: executors, powers of attorney, guardians, and trustees, and their different roles and responsibilities. You can now plan for those in your estate planning documents. You can also look for what the statute calls online tools, certain settings you can set up with your digital accounts at Google or at Facebook to control what should happen to those accounts after you're gone.
So when you're putting together your estate plan, what are some main points to consider when dealing with digital assets?
Some of the main decision points to consider are what level of access do you want your fiduciaries to have? Now, under state law, by default, your executor and your power of attorney are going to have broad access to your digital assets except content of your electronic communications. Those are protected under federal privacy law, and you need to make an affirmative election to allow your executor to get access to the contents of your communication. So if that's something you want your executor to be able to have, you need to specify that in your estate planning documents or look for the account settings to allow that to happen directly through the service provider. Also, because there is this broad default access, you could put provisions in your documents to cut back that access if there are things you'd rather not have your fiduciaries see.
And how can an attorney help me out when I'm planning for what happens to my digital footprint after I'm gone?
Well, this is a new area of the law for a lot of people to be thinking about. So a lot of the form wills that you might see out there are not going to be giving you many powers in these areas at all, or if so, certainly not customized to what your wishes are. So certainly talking to an experienced estate planning attorney about these issues and how to customize the settings that you really want in terms of who should have access to these accounts, who shouldn't, helping you develop an inventory of your digital assets so that your survivors know where to look for your accounts, and all the different steps that are involved in planning for these digital assets. An experienced estate planning attorney is going to put you in a better position to develop a comprehensive plan. Similarly, if you're faced with the death of a loved one who hasn't done this kind of planning, working with an attorney who understands the new laws that we've had here in Ohio for about a year and a half now, and the way to work with the service providers to be able to get access to that information could be a real lifesaver in the right situation.
All right, well, those are all the questions I have for you. Thank you so much for stopping by to answer them.
You're quite welcome.
If you have a legal topic that you would like to learn more about, follow the Ohio State Bar Association on Facebook, Twitter, and LinkedIn, and write to us using the hashtag #LawYouCanUse. And to learn more about estate planning and digital assets, go to ohiobar.org/lawYouCanUse, and thanks for joining us.